सीआरपीसी केस में सबसे पहले हमने अब 12 चैप्टर तक के क्वेश्चन कर लिए हैं। आज हम चैप्टर नंबर 13 से स्टार्ट करेंगे। चैप्टर नंबर 13 डील्स विद द jurisdiction of the criminal courts in inquiry and trials, deal with the section 177 to 189. सबसे पहला क्वेश्चन है कि एन ऑफेंस ऑफ किडनैपिंग can be tried by a court having jurisdiction over the place where the kidnapping has taken, where the kidnapped person is recovered, where the victim was conveyed, concealed or detained. तो इनमें से कोई सी भी जगह पे किया जा सकता है. Where two courts subordinate to the same high court have taken cognizance arises as to which of them shall try the offences. The question shall be tried by any of these courts. The question cannot be decided by any of the courts, and the question shall be decided by the concerned high court. The question can be left to the parties. No, the question shall be decided by the concerned high court. Under CRPC, where two or more court have taken cognizance of the same offense, any question arises as to which of them ought to try that offense, the question shall be decided by the सुप्रीम कोर्ट. नो, इफ़ द कोर्ट आर सबऑर्डिनेट है सेम हाई कोर्ट के तो हाई कोर्ट करेगा, लेकिन इफ़ द कोर्ट्स आर नॉट सबऑर्डिनेट टू द सेम हाई कोर्ट देन बाय द हाई कोर्ट within the local jurisdiction of whose appellate criminal jurisdiction has the proceeding were first commenced. तो सेकेंड एंड थर्ड यहाँ पे सही है. अगला है when there is a dispute between two courts relating to exercise of jurisdiction in a criminal matter and said court are under subordination of different high court, then it was decided by the high court within whose area the proceeding first commenced. Section 183 of the CRPC code applies. of 183 deals with offense committed on journey or voyage, then apply to voyage on the high CGS, apply to voyage within India as well as voyage on high CGS, declared unconstitutional. नहीं, does not apply to voyage on his seas. अजीब सा क्वेश्चन है ये तो. An offense of theft can be tried by a court. Offense of theft can be tried by a court under whose jurisdiction the theft has been committed, stolen property found, and the stolen property is kept by the accused knowing it to be stolen. Any of the above. X है वो email भेजता है Y को from Delhi threatening Y that certain photograph showing Y in compromising position with a woman shall be posted on the net if Y does not pay rupee 1 lakh to X. Y access the email at his office in Calcutta. The offense can be inquired in or tried into Delhi or Kolkata, anywhere in India, because the email can be accessed anywhere in India, both 1 and 2, Delhi or Kolkata. A minor girl lived with her father at Indore. She became intimate with the accused and ran away with the accused from Indore to Bhopal in a taxi. After some time, they eventually settled in Mumbai, and offense of kidnapping may be tried at Indore, at Bhopal, at Mumbai, at any place mentioned above. Ordinary place of a trial is where the offense has been committed. जहाँ पे offense हुआ है वो ordinary place of trial होता है. An offense is committed outside India by citizen of Indian. Such offense shall be inquired or tried in India with the previous sanction of the central government. Offence committed outside India is given under 188 and ordinary place of trial is given in 177. An Indian citizen murders an Australian citizen in Sydney and absconded. He is found by Indian police in Mumbai. He, with the previous sanction of central government, can be prosecuted in India at the place fixed by Foreign Ministry in Delhi. In prosecution in Mumbai only, prosecuted any place as per the request of Australian government. Prosecuted in Mumbai only. He who is a citizen of India commit murder in Uganda. He is arrested in Delhi. He can be tried and convicted of murder. Only in Uganda, only in that country of which the deceased was a citizen in any of the above. In Delhi. दिल्ली में पकड़ा गया तो दिल्ली में ट्राई करेंगे. An offence is committed by a British citizen on an aircraft registered in India. The offender may be dealt with under which provision of the Code of Criminal Procedure 188, because 188 deals with the offence committed outside India. For trial of cases of criminal abatement, which court is only the competent court. Local limit of the court where the abatement was committed, any of the court where abatement intention was alleged, where the wrongful concealment of the accused is shown. All of the above. The premonitory jurisdiction of the court for inquiry is ordinarily where the ordinary offence took place is the proposition admissible under section 177 of crpc. The preemptory jurisdiction of the court for inquiry is ordinarily where the offence took place is the proposition admissible under section 177 of crpc depends upon the place of residence of the accused. Under which section of the CRPC the jurisdiction of the criminal court have been given for the offence committed outside India. 188. A woman sold a minor girl to a prostitute in P city. Later she was taken to M city, where the offence was detected, where the offence can be tried. Either P city or M city. In M city only, in P city only, as the offence was completed as per order of the High Court. In P city only, as the offence was started there. X kidnapped Y from city P and kept Y at city M and was detected there, where the offence can be tried either at city P or at city M. For an offence of bigamy, where the offence can be tried at the court's jurisdiction where the permanent residence of the aggrieved woman after the offence is situated. ये गलत है कि only where the offence was committed, only where the offender reside with his first wife. Only वाला तो नहीं होगा. When two or more courts have taken cognizance of the same offence, in such case the court shall inquire into the offence. If the courts are subordinate to the same court, it will be as per the direction of the High Court. अगला है 14 नंबर. Condition requisites for initiation of proceeding. Proceeding का initiation कैसे होगा अब? Taking cognizance of an offence by a magistrate is a judicial act. Cognizance is taken of the offense. Taking cognizance and issue a process are synonym. The statement is false. Cognizance लेना और process issue करना same थोड़ी है. When can a specifically empowered magistrate take cognizance of an offense upon information when received from any person other than a police officer upon his own assertion by the direction of the High Court? Both 1 and 2. When received from any person other than a police officer upon his own desertion. Which section of the crpc code restrict the court of session from taking cognizance of any offense as a court of regional jurisdiction unless the case has been committed to it by a magistrate? Cognizance of offense by court of session दे रखा है 193 में. In which of the following cases the session court cannot take cognizance of any offense committed by or against a public servant as a court of original jurisdiction? Any case of abatement, any case of attempt to commit an offense, any case of criminal conspiracy, all of the above. All of the above. Magistrate may take cognizance of an offense on complaint if, in his opinion, magistrate may take cognizance of an offense. There is a sufficient ground of proceeding. A magistrate may take cognizance of an offense on police report, on private complaint, on suo motu, all of the above. Which court may take which court may take cognizance of offense under section 190 of the CRPC? Cognizance of offense by magistrate. 190 may any magistrate of the first class, any magistrate of the second class specially empowered in this behalf. For 2 and 3. Under Criminal Procedure Code 1973, Section 192, who may empower magistrate of the second class to cognizance of the offense. CJM. Cognizance of the offense of defamation under the section 21 of IPC can be taken defamation on a complaint made by aggrieved. Cognizance under 498A of IPC can be taken upon police report, upon complaint of victim, upon complaint of parent, brother, sister and victim, all of the above. Under section 198 of the CRPC, no court can take cognizance of an offense against marriage punishable under section 20 of IPC unless a complaint is made by some person who is aggrieved by the offense. One 98 deals with the prosecution for offense against marriage. Next, which section of the CRPC provide for prosecution for offense against marriage? 198. Which one of the following is true about the session court? Session court can take cognizance only on committal. Only on committal. The provision of section 195 of CRPC require prosecution for contempt of lawful authority of public servant, for offense against public justice, and for offense relating to documents given in evidence. A complaint in writing. An oral complaint 1 and 2, neither 1 and 2. कंप्लेंट इन राइटिंग आएगा अकेला 195 में. Under CRPC, provision relating to prosecution of public servant is given under. Prosecution of public servant is given under the section 197. Prosecution of judges and public servants in 197. In 197, judges and public servant. Which section provide prosecution of judges under CRPC 197? The prosecution of judges and public servant are provided in 197. No member of the armed forces of the union shall be arrested for anything done in the discharge of his official duty except after attaining the consent of central government. आगे है कंप्लेंट टू मजिस्ट्रेट. मजिस्ट्रेट को परिवाद करना. 200 से लेके 203 तक है. 200 है एग्जामिनेशन ऑफ कंप्लेनेंट. फिर है प्रोसीजर बाय मजिस्ट्रेट नॉट कॉम्पिटेंट टू टेक कॉग्निजेंस ऑफ द केस. अगला है पोस्टपोनमेंट भी किया जा सकता है 202 में. नेक्स्ट है डिसमिसल ऑफ द कंप्लेंट इन 203. आफ्टर डिसमिसल After dismissal of a complaint under section 203, a fresh similar complaint on the fact is not penned but will be entertained only in exceptional circumstances. All circumstances में तो नहीं करते. Under which of the following section of the CRPC magistrate shall dismiss the complaint? Under section 203. Direction to the police by a magistrate to investigate. Under section 202 of the CRPC cannot be given without examining the complainant on oath. If it appear to magistrate that the offence committed of his tribal exclusive by the court of session, he under section 202 CRPC postponing he issue of process against the accused shall call upon the complainant to produce all his witness and examine them on oath. उसको बुलाएगा एंड प्रोड्यूस करवाएगा ऑल हिज विटनेस एंड एग्जामिन करेगा उनको ओथ पे. अंडर सेक्शन 200 CRPC रिकॉर्डिंग ऑफ प्री समनिंग एविडेंस मे बी डिस्पेंस्ड विद द कंप्लेंट इज मेड इन राइटिंग बाय ए पब्लिक सर्वेंट. Is it mandatory to record pre summoning evidence in all private complaint except where complaint is made by a public servant acting or purporting to act in discharge of his official duties? In a private complaint case, process can be issued against an accused until the magistrate is of the opinion that there is sufficient ground to proceed with the case. If a complaint in writing is made to a magistrate who is not competent to take cognizance of the offence, he shall return it for the presentation to the proper court with an endorsement to that effect. Next is 16 number. Commencement of proceeding before magistrate. पहला है strike out the incorrect statement. No summon can be issued in a warrant case. तो यही गलत है. In a summon case, the magistrate who has taken cognizance can issue summon for attendance of the accused. In a complaint case, a warrant or summon has necessarily to be accompanied by a copy of the complaint. A complaint can be dismissed by the magistrate under section 204 का 4 CRPC. Which of the following procedure defines the term cognizance? Not defined. Committal proceeding under section 209 of CRPC are in the nature of commitment of case to court of session where offense is triable exclusively by 209 में है inquiry type की. Under section 209 CRPC, which of the following case can be committed to the court of session by magistrate if it appears to the magistrate that the offense is triable exclusively by the court of session? A case instituted on a police report, a case instituted otherwise than of police reported, both 1 and 2. 210 can be invoked. Procedure to be followed when there is a complaint case and police investigation in respect of the same offense. When there is a complaint case and police is also investigating the matter, it is dealt with 210. In case of merger of the complaint with the police report, the procedure to be followed for the trial shall be the procedure of the case instituted on the police report. Filing of list of witness by a complainant before issuance of summons or warrant to the accused under section 204 of CRPC is mandatory. Personal attendance of an accused can be dispensed under the which provision of the CRPC? Under 205, magistrate may dispense with personal attendance of accused. 205, magistrate may dispense with personal attendance of the accused. In case tried by the court of session or a chief judicial magistrate, the court or such magistrate as the case may be shall forward a copy of it or his finding and sentence if any to the DM within whose local jurisdiction this trial is held. Which section of the following CRPC the accused shall be supplied the copy of police report and other documents by the magistrate? In 207, supply to the accused of copy of police report and other document. The maximum amount of fine specified in case of petty offences under 206 of CRPC. Special summon in case of petty offences 206 में 1000 रुपए. An offender can plead guilty and pay fine with the help of the postal department under the provision of 206 of CRPC. In petty offences, the accused may plead guilty only in person, only through an advocate above, and also be transmitting plea through post or messenger. सारे तरीके से कर सकता है. Whether a person can send fine amount through postal department? Yes. Without appearing in the court of some petty offences, if yes, under which provision? Under 206 petty offences के केस में. Under 206 petty offences का मतलब क्या है? Any offence punishable only with the fine not exceeding 1000 rupees. Next is 17, the charge. Section 216 of CRPC, court has the power to 216 में है कोर्ट में अल्टर चार्ज. 216 कोर्ट में अल्टर चार्ज. The section 216 of CRPC court has power to add to or alter the charge both. Under which section of CRPC addition and alteration of the charge has been provided? In 216. Which action of CRPC empower court to alter or add to any charge at any time before judgment pronounced? 216. The effect of error in stating the requirement particulars in the charge shall be regarded material under which of the following circumstances? When the accused is misled by the error. Error or omission in framing of charge is material only if it has occasioned failure of justice. इफेक्ट ऑफ एरर्स 215 में दे रखा है. विच रेफरेंस टू द चार्ज which statement is correct? Every charge under the CRPC state that offences with which the accused may be charged. If in the course of same transaction more offences than one are committed by the same person, he be charged at one trial. Both 1 and 2. In revision maintainable against an order on framing of charge. Yes, revision is maintainable. It is necessary to write a speaking order when a charge is altered. No. The provision relating to the charge is given under the chapter 17 211 to 224. A is accused of cheating B at a given time and place. The charge must set out the manner in which A cheated B. For the purpose of the CRPC, who from among the following may determine the language of the each court in the state other than the High Court, the state government? Under CRPC, charge shall be written in the language of the court, which is not a content of charge. Description of a family background of the accused is not a content of the charge. Who can frame the charge? According to the CRPC, court can frame. Which form mentioned in the second schedule of CRPC is related with the charge? Form number 32. When a person is accused of more offences than one committed with the space of 12 months, then he may be charged with and tried at one trial for any number of them not exceeding 3 of same kind. 3 offences of the same kind within 12 months can be charged together as per the provision of CRPC. Under section 219 of the Code of Criminal Procedure 1973, offence of same kind means when they are punishable with the same amount of punishment under the same section of the IPC or any of special or local law, which is not correctly matched. Information in cognizable case 154, arrest by magistrate 44, content of charge 211, trial more than one offense. ये 218 में नहीं है trial more than one offenses. Trial for more than one offenses ये 220 में है. अगला है for every distinct offense of which any person is accused, there shall be a separate charge. Where is the exception to this rule in CRPC? सेक्शन 219, 220, 221 एंड 223. यहाँ पे तो 3 ऑफेंसेस है. 219 में तो 3 ऑफेंसेस ऑफ द सेम काइंड विद ईयर में बी चार्ज टुगेदर एंड 220 में है ट्रायल फॉर मोर देन वन ऑफेंस. 221 में है व्हेन डाउटफुल What offenses has been committed? 223 में है person may be charged jointly. The court may alter the charge before the judgment is pronounced. Whenever a charge is altered or added to by the court after the trial has commenced, the prosecution has right to recall or resummon any witness who has already been examined. Any defect in charge can be cured by amending it with a direction to retrial if such amendment is if such amendment is causing prejudice to the accused. When shall the prosecutor and the accused be allowed to recall the witness? When a charge is altered or added by the court. For every distinct offense of which person is accused, there shall be a separate charge which shall be tried separately. Is provided under which section? 218 में separate charge for distinct offense provide किया गया है. Separate charge for distinct offenses 218. If a series of facts are so connected together as to form the same transaction and more than one offense is committed by the same person, he shall be charged with every such offences and tried at one trial for all the offences. Which one of the following is wrong? When an accused is discharged, the court need not record the reason. ये वाला गलत है. रीजन तो रिकॉर्ड करने पड़ेंगे. जॉइंट ट्रायल को कहाँ दिया गया है सेवरल पर्सन का? जॉइंट ट्रायल इज गिवन अंडर द सेक्शन 223 ऑफ CRPC. When what person may be charged jointly? A is only charged with theft and it appears that he committed the offense criminal breach of trust. Which one of the following is correct? He may be convicted of criminal breach of trust. What at the stage of framing of charge, the session court feel that the case is not exclusively tribal. It frame the charge and transfer the case to the CJM or magistrate of the first class. A is accused of an act which may amount to theft or receiving stolen property or criminal breach of trust. He is only charged with theft. It appears that he committed the offense of criminal breach of trust. He may be convicted of criminal breach of trust though he was not charged with such offense. नेक्स्ट है 18 नंबर का चैप्टर ट्रायल बिफोर अ कोर्ट ऑफ सेशन. 18 नंबर के में है ट्रायल स्टार्ट हो जाते हैं 18 से. तो सबसे पहले है कोर्ट ऑफ सेशन के आगे ट्रायल 225 से 237 तक है. पहला है कि व्हेन ए केस इज instituted under section 199 clause 2 of CRPC, the procedure of trial adopted in such cases trial of warrant case instituted otherwise than on police report. 199(2) में otherwise police report. Section 236 of the Code of Criminal Procedure 1973 lays down a special form of procedure as to the issue of liability to enhance punishment in consequences of the previous conviction. The section is applicable to trial before court of session only. In case of one or more offences to be tried by a magistrate falls in the category of session trial, what court will try the case by the session court? Which one of the following orders can be passed after the trial of a case is over? Either an order of acquittal or conviction. कौन से सेक्शन में प्रोसीजर प्रोवाइड किया गया फॉर ट्रायल बिफोर अ कोर्ट ऑफ सेशन 225 से 237। इन एवरी ट्रायल बिफोर ए कोर्ट ऑफ सेशन प्रोसिक्यूशन शैल बी कंडक्टेड बाय a public prosecutor. A charge is framed by the magistrate on the basis of the police report and document sent with it. A session judge during session trial may order acquittal of the accused person even before pronouncing judgment under which of the following section of the Code of Criminal Procedure. Acquittal का order दे सकते हैं 232 में. Under which of the following provision the CRPC can the accused file written statement in support of his defense? Entering upon defense is provided in 233. 233 clause 2 में यहाँ पे 1933 कैन अक्यूज्ड है फाइल कर सकता है रिटन स्टेटमेंट इन सपोर्ट ऑफ हिज डिफेंस. अगला इफ द अक्यूज इज नॉट एक्विटेड अंडर सेक्शन 232 of CRPC then the court calls upon him to enter on his defense. तो आगे यहाँ पे दिया है चैप्टर नंबर 19. चैप्टर नंबर 19 भी ट्रायल से है. चैप्टर नंबर 19 ट्रायल ऑफ वारंट केस से रिलेटेड है 19 तो. और चैप्टर नंबर 20 है वो समन केसेस के ट्रायल से रिलेटेड है. तो यहाँ पे है ट्रायल ऑफ वारंट केस बाय मजिस्ट्रेट. तो सबसे पहला क्वेश्चन है कि व्हेन द सबसे पहले ये है 238 से 250 तक दिया है. पहला क्वेश्चन दे रखा है कि व्हेन द मजिस्ट्रेट में इन हिज डिस्क्रिशन डिस्चार्ज द अक्यूज्ड both at any time before the charge has been framed and the complaint is absent on any day fixed for the hearing of the case and offence is lawfully compounded or is not a cognizable offence, then he can discharge both at any time before the charge has been framed and the complaint is absent on any fixed day for the hearing of case and offence है वो cognizable ना हो. Next है under code of CRPC a warrant case instituted on a police report. The trial begins when charges are framed. Which of the following states when accused shall be discharged? 239. When accused shall be discharged is given in 239. In which section of the CRPC the trial procedure of warrant case is given under the 238 to 250? The amount of compensation which a magistrate can direct the complainant or informant to pay for an accusation without reasonable cause under section 250 of the CRPC is as he may determine but not exceeding the amount of fine he is empowered to impose. Compensation for accusation without reasonable cause can be awarded by the magistrate under the section 250. 250 में दे रखा है compensation for accusation without reasonable cause. Next, what is not true? Magistrate may discharge the accused if complainant is absent on the date of hearing of offence is compoundable, non-cognizable before charge has been formed. Provision would be applicable for complaint case and police case both. ये वाला ही गलत है. If the complainant is absent on the day fixed for the hearing of the case, the magistrate may in his discretion discharge the accused in certain circumstances. In which one of the following circumstances the accused cannot be discharged? When the charge frame हो गई तब नहीं कर सकते. Compoundable है, non-cognizable है, और when the proceeding has been instituted on complaint तब कर सकते हैं चार्ज के होने से पहले. If the complainant is absent on the day fixed for hearing of the warrant case, the magistrate may discharge the accused if The proceeding has been instituted upon complaint. The offense is non cognizable और चार्ज है वो फ्रेम नहीं हुआ इन सभी केसेस में. When in any warrant case instituted otherwise than a police report, the accused appear or is brought before a magistrate, the magistrate shall proceed to hear the prosecution and take all such evidence as may be produced in support of the prosecution. If in a trial of a warrant case, the magistrate find the if a trial of warrant case, the magistrate find the accused not guilty, he shall acquit him. When in any warrant case instituted otherwise than a police report, the accused appear or is brought before a magistrate, the magistrate shall proceed to hear the prosecution and take all such evidence as may be produced in support of the prosecution. Which one of the following section of the CRPC deals with the evidence for defense? 243. 243 Evidence for defense. Hearing on sentence by magistrate is required on conviction in a warrant case under 248(2) of the CRPC. Acquittal or conviction. Hearing on sentence by magistrate required on conviction. Which of the following deal with the absence of the complainant? Absence of the complainant is under the 249. In respect of cases instituted otherwise than on police report, under which of the following section charges are framed? Two 46 Procedure where accused is not discharged. Trial by summon cases by magistrate. Trial by summon cases by magistrate 251 से 259 तक. Withdrawal of complaint result in the acquittal of the accused irrespective of whether the charge has been framed or not. विड्रोवल ऑफ कंप्लेंट से क्या होगा? एक्विटल हो जाएगा एक्यूज का, चाहे चार्ज फ्रेम हुए हों या फिर नहीं हुए हों. एन एप्लीकेशन फाइल्ड अंडर 257 ऑफ द CRPC of criminal procedure code is allowed, so the accused will be acquitted. 257 Withdrawal of complaint. Which provision of the CRPC deals with the withdrawal of the complainant? 257. In a summon case, when the accused appear or is brought before the magistrate, it shall not be necessary to frame a formal charge. In a case the accused was found guilty and sentence was pronounced on the same day, is it legal? No. The trial in summon case commences with the appearance of the accused. Can magistrate convert a summon case into warrant case? Yes. When in a summon case the accused appears, वारंट केस है, समन केस वारंट केस में चेंज होता है 259 में. When in a summon case the accused appear or is brought before the magistrate, the particulars of the offence of which he is accused shall be asked whether he pleads guilty or has any defence to make, but it shall not be necessary to frame a formal charge. In the trial of summons case by a magistrate, in the trial of summon cases by a magistrate Only substance of accusation is to be stated. In reference to the trial or summon cases by a magistrate, which of the following statement is correct? There is no requirement for the court to hear the accused, and the particulars of the offence shall be stated on him. The procedure for the summon cases is provided in the following section of the CRPC 251 to 59. Power of court to convert summon cases into warrant cases provided in 259. Stoppage of proceeding in criminal case has the effect of if acquittal in all circumstances, acquittal where the evidence of the principal witness has been recorded, discharge in all other cases where the evidence of the principal witness has not been recorded, acquittal in all circumstances तो नहीं होगा स्टॉपेज ऑन प्रोसीडिंग से बाकी दो सही है In the interest of justice of a magistrate has the power to try someone case as a warrant case where the offence to be tried then under is punishable with the imprisonment. None of the above. In which of the following circumstances magistrate has power to convert summon cases into warrant case in the interest of the justice? In case of in which of the trial hearing of the accused on sentence is not necessary? In trial of summon case hearing of accused is not necessary. Whether in a summon trial case instituted otherwise than upon complaint, a magistrate of first class can stop the proceeding and discharge, not acquit the accused without pronouncing judgment. Yes, for reason to be recorded where evidence of principal witness has not been recorded. नेक्स्ट 21 जिसमें दिया है समरी ट्रायल्स 21 में है समरली ट्रायल 260 से 265 तक। सबसे पहले है क्वेश्चन सीआरपीसी में द मैक्सिमम सेंटेंस टू इम्प्रिजनमेंट awarded in summary trial is 3 months. Under which one of the following section the CRPC 1973 of Magistrate of Second Class can conduct summary trial? Under 261. Summary trial by magistrate of the second class JMFC JMSC second class 261 में दे रखा है। In summary trial which trial procedure the court should follow? समन ट्रायल वाला होगा summary trial में the summon trial वाला। Which of the following offense is not triable summarily? Grievous hurt को नहीं करेंगे summarily trial। Which of the following offences cannot be summarily tried? Grievous hurt. Under CRPC 1973, who empowers the judicial magistrate of first class for summary trial? The High Court. Power to try summarily is given in 260. Under CRPC Code 1973, what will be the effect of trial conducted at wrong place? Vitiative caused failure of justice. Which of the following court can try summarily offences mentioned in section 260 of CRPC? Any chief judicial magistrate, metropolitan magistrate, any magistrate of the first class specially empowered by the High Court in the behalf all of the above. Which of the following is not tried by summarily? वो ऑफेंस जिसमें 2 साल से ज़्यादा का पनिशमेंट है। Which one of the following offence is triable summarily? Offences not punishable with the death imprisonment or life imprisonment for a term exceeding 2 years is not punishable under summary trial. Not to be tried summarily. offense punishable with imprisonment up to 3 years is not tried summarily. Under which section of the CRPC provision regarding summary trial is given? Under 260 to 265. Any metropolitan magistrate may, if he thinks fit, try in a summary way the following offences under section 260 of the CRPC: theft under 379, 380, 381 of the IPC where the value of the property stolen 2000 से ज़्यादा ना हो, 454 या 456 of the IPC, and the receiving or returning stolen property under 411 of the IPC where the value of the property does not exceed 2000 rupees. All of these. नेक्स्ट है 21A चैप्टर प्ली, हाँ बार्गेनिंग से रिलेटेड है. 265A से स्टार्ट होगा ये. 265A से 265L तक दिया गया है.